So today I'm planning to talk about legal issues that impact landowners. So primarily I'm going to be talking about leasing issues as well as issues that impact surface owners. So that's going to be the main focus of the presentation. I certainly want to make this interactive with a group this size. I think we can respond to your questions as they come up. So we can, I have a PowerPoint, have a presentation, but if this kind of turns into a discussion, that's fine as well, and we'll just I'll try to move things along, so we try to stay generally on focus of talking about the leasing and the surface owner issues. Just a little bit about myself. I'm on the faculty of the law school here at Penn State, and I'm director of the Agricultural Law Resource and Reference Center. That was established by state statute when Penn State and the Dickinson School of Law merged back in the late 90s. And the legislature found at that time that there really did not exist an entity to compile information and disseminate information on the wide range of issues impacting agriculture. So the purpose is to serve as a resource to that wide variety of constituents on those issues. So I accomplished this mission of disseminating information, and that's kind of how I interpret the mission, is really to disseminate information through presentations, educational programs, publications, electronic newsletter, website, and we've started some blogs as well. Now, with regard to our website, we have a number of different resource areas. So if you're interested in information on Pennsylvania's right to farm law, or clean and green, or the ag area security law, some agricultural specific statutes, we have a pretty extensive collection of the resources on that statute. Now, we also have a Marcellus Shale resource area that has links for statutes, regulations, court cases, other legal resources related to Marcellus Shale. Now, we are not an advocacy organization. We really are trying to disseminate information. So we're trying to provide information about what the statutes, what the regulations, and what the laws are on this topic. And I've done a lot of presentations to landowner groups about leasing and trying to advise them or inform them of the issues that arise in the leasing process so that they can make the best decision to protect their interests as they're signing leases or contemplating signing leases. So today, these are the four basic topics that I want to cover in this presentation. First, the Marcellus Shale background, and if you were in my presentation yesterday, this will be, you'll see a lot of familiar slides in that first section, but the context is a little bit different when you're looking at leases versus government regulation. But then we'll move on to the leasing issues, and that's where we'll spend the bulk of our time today, on leasing issues. Then we'll talk about some general oil and gas law concepts to help you understand some of those issues, and then we'll talk about surface owner rights. So the situation where you have the surface owner does not own the natural gas rights, and what is the ability, or what actions can that surface owner take. Okay, so just some background, just to put the issue into context. The oil and gas exploration is not new in Pennsylvania. The first oil well was drilled in Pennsylvania and outside Titusville. The Haymaker well was a very early natural gas well outside Pittsburgh, and so Pennsylvania, or Western Pennsylvania, was very much at the center of the early extraction activities. Pittsburgh was the first city to have natural gas piped to it in 1883, and just looking at the data from the early 1900s, you can see Pennsylvania was really very much the focal point of where natural gas extraction was taking place. 43% of the natural gas, the value of natural gas in the U.S. was from Pennsylvania. 37% of the active gas wells, 42% of the pipeline miles. So there was a lot of activity. Probably more so than any other state, was happening in Pennsylvania. When you move forward to 2005, which is at the beginning of the Marcellus extraction, Pennsylvania had declined to 16th nationally in annual natural gas production, but it still was 3rd nationally in the number of active gas wells. So that kind of paints a picture of the industry in Pennsylvania, that we had a lot of wells, but they were relatively low producing wells. And of course they were concentrated in western Pennsylvania. The first Marcellus well was, or the first gas extracted from a Marcellus well was in 2005 in Washington County, the Rents #1 well, and that really marked a transformation, even though it was really a relatively quiet transformation because the general public wasn't aware that anything different was happening at that time, but it certainly was within a few years. Marcellus Shale became a much talked about topic, and I think really it was probably about 2008 that it started to be a topic that was getting a lot of attention. With the drilling of that well in 2005, you started to see a lot of increased activity on the leasing side. A lot of leasing was taking place, and landowners still were really unaware of all of the facts behind that, but they certainly were aware that they were getting approached more frequently, or the dollars were much higher than what had been offered previously. The expansion of the activity, drilling and leasing into areas of Pennsylvania that did not have a history of oil and gas activity, and the use or adaptation of technologies that had not been done before, the horizontal drilling and the hydraulic fracturing, which those technologies had been used before, but they were being used in a new manner with the shale gas extraction. So there certainly were a lot greater dollars that were being offered to landowners. There's just a lot of dollars that were really driving the activity on a lot of different fronts. We had a lot of international companies that were getting involved as well, a lot of acquisition of companies. So what is Marcellus Shale? Some of you, or maybe all of you, have some familiarity with this, but it's natural gas that's actually contained within the shale rock. And gas Marcellus Shale, or any shale, is referred to, or has been referred to, as a source rock because that's where the gas was originally deposited. And it's not very porous, it's not very permeable, so the gas does not flow through the shale very quickly, but it does flow through the shale, and over thousands or millions of years, some gas had migrated out of shale into sandstone and was captured in reservoirs, and that's what was extracted through historic natural gas production. So we had Marcellus Shale or other shales as source rocks, and then you had sandstones as reservoir rocks. With the hydraulic fracturing and horizontal drilling, companies are extracting gas directly from the source rock rather than waiting for that gas to migrate into the reservoirs in the sandstone or other formations. So this is a map that shows the distribution of the Marcellus Shale, and I'm sure you've probably all seen this map before, but the one thing I want to point out is the dotted line that really starts in the southwestern corner of the state and runs northeasterly, and that's a division between wet gas and dry gas. Wet gas is gas that has a lot of constituents like propane, butane, that have to be taken out of the liquid-based products that have to be taken out of the gas before the gas is put into the pipeline. So the gas requires more processing, but it's more valuable. And that's particularly so true today, where you have natural gas at a low price, oil is at a relatively high price. Those liquid-based components are priced more on the oil market than the gas market. So right now, gas that's extracted from the so-called wet gas is more attractive to companies than dry gas. So the Bradford County, Susquehanna County, that's dry gas. Washington County, that's wet gas. And so from a leasing standpoint, that's important because it's likely that the land real estate that's in the wet gas area is likely to be more attractive to companies than that in the dry gas areas. This is a map showing the different shale basins, the natural gas shale basins in the U.S. So you can see that the Marcellus is not the only shale. The Utica, you've probably heard about it. It underlies the Marcellus, is a little bit western, shifts into Ohio. But these are just two of the many shales that are in the U.S. So why is there so much focus on the Marcellus? It's very large. If you look at the total size of the Marcellus and compare that to other shale, natural gas shale basins, the four basins that have been developed probably the most, or certainly the earliest, would be the Barnett in Texas, the Woodford in Oklahoma, the Haynesville in Louisiana, and the Fayetteville in Arkansas. If you combine those four shales, the Marcellus is 4 times larger than the combined size of those four. So it is very large. It has been productive. It's close to the natural gas is still used primarily for heating. And where do you have a high demand for natural gas for heating? In the northeastern cold weather cities, Boston, New York, Philadelphia. So being located in the Northeast reduces the transportation costs, so it makes it more attractive. So that's some of the reason why there's been a focus on the Marcellus as opposed to some of the other shales. And there certainly is activity in other shale formations as well. Okay, so that, I guess this map shows you a distribution of the wells from 2007 to 2011. So you can see the two general concentration areas, one in southwestern PA in Washington, Greene, Fayette, and a little bit into Westmoreland County, and then in northeastern, north central PA in Bradford, Susquehanna, Tioga, Lycoming County are really the two main concentrations. But you can see there are wells in probably 30-something counties throughout the region. Okay, so that's as much as I wanted to go into detail on the background, but just to kind of sum up the history of development in Pennsylvania, because we had a lot of activity in the 1800s, the case law, there's quite a few court opinions that were issued in the late 1800s and early 1900s, but then through the 1900s, a relatively small amount of activity. And so there's a relatively small number of court cases. So what does that mean for you today as landowners that have leases? It means that you may have a lot of questions about how leases are interpreted, but there are no answers because a court has not made a decision on that particular issue. So, we're in the process of kind of developing the law. Certainly, court cases are being developed that are shaping how that lease relationship is going to be interpreted. Okay, so now to move on to the lease agreements, and just so I can kind of get an idea of what your interests are, how many of you have signed a gas lease? Okay, and how many of you are contemplating signing, own real estate, haven't signed a lease, but are kind of contemplating signing a lease? Okay.
Will this be on the website, the PowerPoint?
We have some of Ross's PowerPoint slides and also a video from a longer presentation that he gave in Western Pennsylvania on Pasa's website. So you can find it at www.pasafarming.org/Marcellus Shale Choices. I'll write it down here for everyone, and you can find the slides for a longer presentation that includes this piece as well as a video.
Thank you. Sorry to interrupt.
Oh, that's fine, and you can also just send me an email, and I can send it to you as well. Okay, so the leasing process is normally going to start when the gas company or someone working for the gas company presents the landowner with a standard lease. And this lease, you're shaking your head no.
Yeah, well, there's no standard lease.
Well, you say there's no standard lease.
We might have a standard lease, but
it's a lease that has been. What's that?
It suits their needs.
Exactly. It's a lease that suits their needs. It's a lease that was prepared by the gas company. It's protecting the interests of the gas company. And there certainly are variations, but when I say standard lease, it's likely going to be the same lease that they offer to you as the one that they're offering everyone else in your community or in your county. And the way that you should take that lease, and you should make sure you understand everything that's in it, take it to an attorney, and what you should do is look at it, and if it's not protecting your interest, if there's something that needs to be changed or added to that lease, you negotiate an addendum that's added to that lease. So the addendum is really a separate document, and that will have the terms that are different from that basic lease. The reason that you don't just start from scratch and negotiate a whole brand new lease is that companies generally, they know what's in that lease. They don't want to make changes to that standard lease. They would prefer to have everything identified as to what's different in your lease. So negotiating an addendum is normally the way that a landowner will protect their interest. A lot of companies have started presenting the landowner with an addendum as well. So they'll have a lease and they'll have an addendum with that as well, which does have some landowner-friendly provisions, but it still isn't necessarily protecting your interests. So if you are presented with a lease and an addendum, you still should treat that the same way you would a lease and review it, make sure that all the terms protect your interests, and then you may want to negotiate a second addendum or some other document that is going to have terms that are going to control what's in the lease agreement. And it's very important that all of the issues are addressed on the front end, because the lease is going to govern nearly the entire relationship between the landowner and the gas company. There are some minimal protections under state law, but really not a lot of protection. So you need to make sure that lease covers it. And so that's all the activities that are going to take place. A lot of times people, when they sign the lease, they don't think a lot about it. And then by the time development comes and you have the rig and you have the other ponds or other facilities, they don't like what's happening, but it's too late because they've already given up those rights when they signed the lease agreement. So it's important to make sure you understand everything on the front end and include provisions that are going to protect your interests. People often ask about leasing groups where landowners come together to negotiate a lease. Some groups have had some success. Certainly it's the bargaining power is maybe a little bit more equal if you have a large amount of acreage, but I think it's important for landowners to understand what their individual interests are and make sure that their interests are aligned with the group. Some groups are concerned with maximizing income, and so their sole focus is on getting as large of a bonus as they can get, or as large of royalties as they can get. But an individual landowner may be more concerned about surface disturbance and may want to have provisions to minimize the surface disturbance. And if that's the focus of an individual landowner, it's not a good match for that landowner to be in a leasing group that's looking to maximize income at any cost to surface protection. So it's important for landowners to make sure they're on the same page with their leasing groups, and also to understand everything before it's signed, because there may be some documents that need to be signed that are not the lease themselves, but they can bind the landowner to sign a later lease if it meets certain requirements. So anything that's signed, the landowner needs to understand that. Okay, just to break down the terms of the lease, I kind of break a lease into 5 different categories. The parties to the lease agreement, the description of the property, the length of the agreement, the payment terms, which is what the landowner is receiving, and then any type of contract or agreement, you get something and you give up something. So you're getting various types of payments, you're giving up rights to the natural gas and rights to the surface estate. Okay, the parties is relatively simple. You have the lessor That's the landowner or the owner of the natural gas rights that is granting those to the lessee. The lessee can be an independent landman who is just looking to flip that lease, to sell that lease to someone else. It could be the gas company. It could be a local drilling company that may not be planning to drill a Marcellus well, but they would sell that lease to someone that could drill a Marcellus well. Most leases will provide that they are freely assignable, meaning the company that you sign the lease with may not be the company that drills the well. But the terms of the agreement are not going to change when it is assigned. So when you negotiate the terms, those terms are going to stay the same regardless of who the company it is that actually holds that lease. Okay, how's a property going to be described? It's going to be described in a lease really similar to a real estate deed. And I guess that highlights the point that an oil and gas lease really is not a lease like a lease for renting an apartment. It really is a property conveyance. You are, as the owner of the natural gas rights, you are conveying an interest, a property interest in the natural gas. So at the end of the lease, you may get all of those rights back. You may get some of those rights back. Those rights may be fully exhausted, but you are granting rights to the natural gas. Okay, the length of the lease agreement is composed of a primary term and a secondary term. The primary term is the number of years. So a typical primary term in a Marcellus lease is 5 years. It can be longer, it can be shorter, but it's a defined number of years that's stated in the lease agreement. So a lease will have language something like, this lease shall last for 5 years and so long thereafter as oil or gas is produced in paying quantities. But the 5 years part of it, we'll talk about that so long as gas is produced in paying quantities in a minute. The 5 years is the primary term. And it essentially gives the gas company an option to develop the lease within that time. So the company has 5 years to develop the property. If they do not develop the property within 5 years, that lease will terminate. That grant expires. If, however, they start development activities within 5 years, then the lease is converted into the secondary term. Now, I've used the term start activities. On the slide, I used production activities. It depends on what's stated in the lease agreement. So the lease agreement will say what conditions have to be satisfied to convert that lease from a primary term into the secondary term. A lot of leases will use a term like commencement of operations, which is fairly vague. You know, what is commencement of operations? Does it mean that you park a truck on there? Does it mean you shovel, you have one shovel full of dirt? Does it mean you actually have to drill the well? I think you want to be as precise as you can when you're drafting a lease. I think probably the most precise term would be talking about spudding the well, where the drill bit actually hits the ground. But you could use some other term. But from a landowner's perspective, I think you'd like to have that be clear as to what is going to constitute the trigger to convert that primary term into the secondary term. The primary term can be extended in a couple of different ways. A lot of leases will have a renewal option or a renewal built into the lease. So the gas company has the option to renew that lease. So what a landowner thought was a 5-year lease is really a 10-year lease. Some of them that may give the company the option to renew, but regardless of how it's structured, whether it's automatic or an option, it's never going to be in the landowner's interest to have a renewal clause, because if the lease market increases, you've locked in your payment terms at the current market. If the lease market declines, well, then the company's not going to exercise the renewal. So you're never going to take advantage of an increase in the market. One option, which is a little better from a landowner's perspective, is a right of first refusal, where you have the ability to negotiate a lease but the company has the right to match those terms. Now, some companies may not want to give you an offer if they know that the existing lessee has the ability to match that. So the best option for a landowner is to have no renewal clause. But certainly a right of first refusal is better than a automatic renewal. Okay, so the secondary term begins when you have whatever that triggering event is that occurs to convert the lease from the primary term to the secondary term. And it's based on some production activity. So the secondary term is going to extend far into the future until you reach another triggering event that's stated in the lease. And a common triggering event at the end of the secondary term is so long as gas is produced in paying quantities. So as long as that well is producing, the secondary term will be in effect. And we have that situation. A lot of wells in western Pennsylvania have been active for a long time, maybe 100 years. You've had a leasehold that has had a continuously productive well. So it's possible for these leases to last for a very, very long time in the secondary term, for through your lifetime, your children's lifetime, your grandchildren's lifetime. So it's very important to make sure that you have those protections when you sign the lease. When that well is in the secondary term, when you have that commencement of operations, it's said to be held by production. And as long as a well is held by production, or as long as a leasehold is held by production, the landowner cannot sign an additional lease. Essentially, the company that holds the lease has control over what is going to happen on that leasehold. Okay, let's talk about any questions about that. I'm going to talk about some of the payment terms. Yes?
Yeah, if you have a shallow well, so
Yes.
in production, does that give that company the right to the deeper shale?
Okay, the question is, if you have a shallow well on your property, does that give the company the rights to the deeper shale? Most questions that are asked, there's two answers that are going to apply to just about every question. The first one is look at the lease and see what the lease says, exactly what's the language on the lease. And then the second issue is a lot of issues in Pennsylvania haven't been resolved. So you have to see how that, if the lease doesn't resolve it, you have to see, is there some case that has interpreted that issue and resolved that question. So that's not the answer you wanted. So I'll give you a little bit more detail now on your question. But first you have to look at the lease agreement. And does the lease just say gas? Does it say all gas? Does it limit it to a particular strata? It is possible to limit the grant, what you're giving up, to a particular strata. Now, that's not common, and that's certainly not common for old leases. That's a little bit more common today. If it doesn't provide a limitation on that grant, then I think there's a question of does it mean all gas? A court interpreting that would have to look at what was the intention of the parties when they signed that agreement. What did they intend? Did they intend to include all of the gas from the surface to the center of the earth, or did they just intend it to be in a particular strata? I think the answer is it probably includes all the gas. If your lease does not say that, but I think you could make an argument that if it was not known at that time, the techniques that are being used today were not known, they were not contemplated, the parties could not have intended to include that gas within the lease. I think you could make that argument, but a court has not addressed that argument. I think there's another argument that you could make, which is that the company has an implied duty. Gas companies have certain implied duties, even those that are not specifically mentioned in the lease agreement, to develop that leasehold. And I think you could argue that they have an implied duty to develop, all strata that could be productive. And if they haven't developed that Marcellus, then they have violated that implied duty to you, and therefore you could sign the lease with someone else. I think we're early enough in the Marcellus development that it probably would be a difficult argument to make today. 10 or 15 years down the road, maybe that argument would be more successful. So I've probably initially gave you not enough of an answer, and then I gave you too much of an answer, so hopefully you kind of got what you were looking for in the middle there.
Which argument is too early? The second one about not developing the Marcellus right away?
The question was which argument is too early, questioning whether it was the second argument about it just being a little too early to have developed the Marcellus. Yes, I think the standard when you're looking at whether a company has violated an implied covenant to develop or an implied covenant to explore, they're held to what's referred to as a reasonable operator standard. So it doesn't mean that they have to immediately go out and develop the entire leasehold, because that's not, a reasonable operator would not do that. And because we're so relatively early in the Marcellus, I think it would be hard to hold a company to a standard that they had to develop that when they haven't had enough time really to develop all of the leaseholds that they have. Now, the first argument, though, about what was intended, I think that's an argument that could be made today. I'm not sure how that would come out, but I think you could make an argument that a lease that was signed in the 1920s, the parties just could not contemplate that these technologies would be used today, and even though the lease said gas, it really was just talking about the sandstone gas that could be extracted with the technologies that were known at that time. I think you could make that argument. I don't know whether it would be successful or not.
What about one that was signed in the 60s?
I think it's the same issues. I think it's obviously collectively knowledge has increased somewhat as we've gone through time, but these technologies still were not used at that time. So I think you could make the same argument.
But the gas company will tell you that they knew that it was possible that was going to happen.
And that would be the argument on the other side.
Right.
And a court would have to determine what did the parties intend. And I'm a little surprised that issue hasn't come up yet. And maybe there are some lower court decisions where that's being addressed. But I'm not aware of any decisions that have addressed that issue. Well, there's certainly being a lot more cases decided now. And you're asking about disclosure. What obligation do landmen or someone that is trying to get a landowner to sign a lease, what obligations do they have to disclose information? They have no obligations to disclose information. You mentioned that a lot of landowners were unhappy with the leases that they signed, and there has been a lot of litigation in the last few years with landowners trying to get out of that lease that they signed. One of the theories that they were relying on, a legal theory, dealt with the application of Pennsylvania's Minimum Royalty Act, and it's kind of an argument whether post-production costs could be deducted from the royalties. So that was really a legal theory. You had a lot of landowners that weren't happy, so that's a theory that had a little bit of traction, was ultimately unsuccessful. A lot of landowners have raised the theory of fraudulent inducement, and I think this goes a little more directly to what your point is, where the typical fact pattern would be that the landowner was the landman represented to the landowner that you better take this offer because we're never going to pay more than this. So we're offering you $25 an acre. We're never going to pay you more than $25 an acre. So, well, and that's the argument that's being made is that statement was served as inducement. It was fraudulent, and therefore that lease should be invalidated. There have been none of those cases have actually gone completely through the trial process. There have been some preliminary motions that have been decided that have basically ruled that that's a factual issue, so it survived the motion to dismiss, but the issue was not completely resolved. So some of those issues are still working through the court system. There was one case that was dismissed at an early stage, and the facts in that case, the landowner had actually gone to an attorney, and the attorney told the landowner that other people had received more, and so on the basis of the landowner having that knowledge, a fraudulent inducement claim was struck down at the early procedural step.
But the landowner will almost always run out of money way before these well-financed.
Well, in the comment that landowners will run out of money before the industry will, I think that generally would be true if you're talking about one landowner versus one company. I think one of the reasons that the Guaranteed Minimum Royalty Act cases had enough momentum to at least make it through through to a final decision was there were a lot of landowners that were involved in that litigation. So a lot of those cases, there were probably about 70 or 80 different cases that were pending, and some of those cases had over 100 landowners. So the landowners that had a similar issue would consult with an attorney, and then collectively those landowners had the resources to pursue the litigation. And I think that probably, we may see that in other issues. If you have a number of landowners that are affected by the same issue, then those landowners can pursue a remedy collectively.
But they don't talk to each other very often because they've been manipulated against each other by the landowner.
Well, landowners don't often talk to each other.
By the landmen, they pit people against them.
Well, landowners often don't talk to each other, and they might be told, well, we're giving you a sweetheart deal, but don't tell your neighbors because then they'll get upset. But in any event, each individual has to approach this as a very important transaction, and I think we are beyond the point where landowners should just be signing, just relying on good faith. I mean, I understand that 10 years ago, 5 years ago, landowners were not paid much to sign a gas lease. I know growing up, I grew up in western Pennsylvania, there were gas wells around, and the technology was different, but you weren't paid much. And if you're only getting paid $5 an acre for your gas lease, you're not going to go to an attorney and spend a couple $100s to find out you're in the hole if you've done that. But I think now the dollars that are being paid are sufficient. There should be enough knowledge that people at least might not know everything, but they at least should know this is important. It's going to have a long impact. I need to make sure that I protect myself.
But who has the liability after the driller goes bankrupt and the landowner is still left with the liability for the pollution, which can go on for 1 million years if it's radioactive?
Well, there's a question about liability, and we'll talk about liability a bit later.
Bond that. An insurance company will bond a nuclear power plant. How are they going to bond this?
Yeah, I mean there is a liability question, and I'll get to that. Yes.
I don't want to draw this out because I know you need to move on here, but would it be fair to say that the warning you're giving us is, given current legislation such as it is, and the current state of case law, lies of commission and indeed lies of omission and lies of commission that are not specifically addressed in the lease are perfectly okay? You either protect yourself or
Well,
expect to be lied to. Is that a fair?
Everything you want to make sure everything's in writing, and that's not just gas leases. That's in everyday business. Everything needs to be in writing because this is I can't make a flat generalization because there are some exceptions to it. But for the most part, when you have a written agreement, anything that is said is irrelevant because it's all incorporated into that written agreement. And so putting that in the context of gas leasing, when certain representations are made about how things are going to proceed, everything has to be in that lease agreement.
I'll take that as a yes.
And everything, well, I guess, the question was whether they can lie, and I'm not saying they can lie, but I'm saying if I'm on the other side, I'm going to make sure that I'm protecting myself by getting everything in writing, and then it's irrelevant whether they're lying or not, because The only thing that really truly matters is what's in that agreement. And then all of the statements that are being made doesn't matter. A lot of obviously when somebody wants you to sign a gas lease, they're going to try to establish a relationship like you would in any other situation. You go to buy a car, they're establishing a relationship, trying to establish a relationship with you. But even if you really, really, truly like, respect, believe your land ban, and even if everything that they're saying is what they truly believe, they might assign that lease to somebody else. And so the person that you've been dealing with may turn out not to be the company that drills a well. So that reinforces the fact that everything's got to be in writing.
Audio and video recordings don't count.
No.
Well, in a general sense, there are some exceptions, but for the most part, why do you need audio or video? Just put it all in writing.
Our landman wouldn't let us video it, or wouldn't let us, I said to him, will you put this in writing, what you're telling me now? And he said no. And I said, well, can I put it on tape? And he said no.
Well, I think if someone won't put it in writing, then there's a red flag. If there's no issue, then you put it in writing. And it might be that they're going to have to get it approved by someone else if they put it in writing. Okay.
They threaten eminent domain to intimidate.
I don't want to take up your time too much either, but I have a lease in West Virginia that I signed back in about 1983, 85. The individual, Ritchie Petroleum, that I signed with, didn't have the rigs, to be doing this, but the lease said that it was non-transferable.
Okay.
Okay. Ritchie Petroleum, they hired Ohio Black Gold, or they worked out with Ohio Black Gold. They came in and they drilled a well. And there are a couple questions I have. One being, they went into the Devonian Shale. Shale levels are pretty much like the sand levels. You might have the squaw, the engine, the different levels of sand formations.
There are many
So
yes.
basically, the Devonian and the Marcellus might be available under this same piece of property.
Correct. And there could be a number of other shales as well.
Right.
So there are multiple shales. And I apologize for not completely repeating the question, but I'll try to make sure that I incorporate all the content in it. But there are multiple, or there can be multiple shale layers below particular property.
So my question was, since I implicitly allowed them to do what they did, if they wanted to come in then I sold the property, or a portion of the property. I still own the mineral rights under the entire piece, and I wondered whether, say they decided they wanted to come into to do another well, or to go down into the Marcellus or whatever. Does the person who owns the property now, or is there any recourse that person could go back if they looked at the lease, say the individual bought it from me, looked at it and saw that they weren't able to assign things to different companies, and Ritchie Petroleum aren't the ones who are actually doing the drilling? Do you know if there is recourse on that? I'm sure it's something that you might say would need to be litigated just like all these other things, and never has gone through. But in this case, I made the deal with them. These people bought the property with the deal the way it was written up. And if somebody came in and tried to...
Well, I think when you sell property, or if you hold on to the mineral rights, the natural gas rights, and then you convey the property, that's all public knowledge. When the person that you sold the property to bought the property, they could do title work, and they should have had title work done, which would have revealed that you were not conveying the mineral rights to them.
Right, that's not really
so,
the question. That's not the question. The question
Right.
basically is if the...
But the fact that
the
Ritchie...
assignability of...
Yeah, so your lease had that it couldn't be assigned.
couldn't
And
be
so Ritchie, they hold the lease,
Right.
but often there's so much subcontracting that occurs in the industry that they still could hold the lease and have someone else develop it, but they would still be the owner of the well. But if somebody else is controlling that property, then I think that would violate the lease. But it's hard for me to see how that could result in any claim against you as the person that signed that lease. Okay, so we'll run through the payment terms. The bonus payment is a one-time payment that the landowner gets when the lease is signed, or normally 90 or 120 days after the lease is signed. There's no requirement, and what I'm stating is Pennsylvania law, there's no requirement that a landowner receive a bonus payment. So it's completely negotiable how much or whether or not you receive that. Delay rental payments are payments that are being made to a landowner in exchange for a delay in drilling the well. So they normally are made on an annual basis in an amount that's stated in the lease agreement. There's no obligation that they be paid, but most leases will have a delay rental payment obligation. Often those delay rentals are nominal and they can be paid up front in what's called a paid-up lease. So it's possible to have a lease where there is a bonus that's paid, and then that lease still would have maybe $5 a year delay rental payments, and they pay that up front. And there are some reasons why it's in the company's interest to have a delay rental provision. I won't go into that. But from the landowner's standpoint, they're paid generally on an annual basis, but if a well is drilled, then the obligation to make a delay rental payment stops. So if you have the option of receiving your money in a bonus or receiving it as delay rental payments, you have to consider some factors. One, certainly money now is better than money later that you may never get, but money now means taxes now. And if you can get that money spread out over time, you get those taxes spread out over time. So, which do you prefer? I think that depends on your individual circumstances. But certainly, if there's a delay rental payment obligation, a company could decide, we're not interested in making this payment anymore. We're just going to let the lease expire, so we're not going to make that payment. Royalty payments, this is the one payment that is required under state law. Pennsylvania states that a lease is not valid unless it provides for at least a 1/8 royalty. And for many years, that was the standard. It was 1/8. Everybody got 1/8. I think now you're probably looking at more of 15 is probably more of a standard. But you can certainly negotiate for a higher amount. Shut-in royalties, these, again, there's no requirement, but your lease can provide that you get a payment if the well has been drilled, but it's not productive. And that's normally going to be because there's not a pipeline infrastructure in place. But the lease could provide, just for economic reasons, that a company wouldn't market the gas. So it's possible that maybe with gas prices low now, company just decides they're going to shut it in. And the lease may give them the authority to do that.
What happens if it's shut in by an earthquake?
If it's shut in by an earthquake,
The well's still there, it's shut in by an earthquake and production is stopped.
if shut in by an earthquake, I think you would have two issues to consider. One, just the general shut-in provision of a lease. Does that apply? And there may be a force majeure clause that would excuse the performance of the company as well. Free natural gas was a payment that historically many landowners signed leases for the free gas. This is something that generally is not contained within Marcellus leases, but if you do have a free natural gas provision, the landowner is going to be responsible for getting that gas from the well to the house.
The Marcellus gas is not good enough, really. It has certain characteristics that make it unsuitable for most domestic.
Well, it's not inherently unsuitable, but it's going to require certain processing because of the pressure. And frankly, the volumes of gas are much higher with Marcellus than traditional production. So, companies don't like the free natural gas provisions because even though the landowners are responsible for getting the gas, when there's a problem, the companies get sued. And so companies would rather not have an individual getting gas out from the well into their house. They'd rather just pay it. And sometimes you can negotiate a payment in lieu of free gas, where you just get a flat payment instead of getting that free gas. Some other payment opportunities, a well siting fee. So if a well is actually put on your property, you get an additional payment. Storage rights and pipelines, we'll talk about those in a little bit, but there can be additional payment. And then often for seismic activity, most landowners, when you sign a lease, you are granting the right to the company to do seismic work. I mean, that's something that is part of their ability to develop the property. But often you'll have different companies that may have some connection with the company that holds the lease that are doing the seismic work, and they will often approach landowners to sign the agreement. There normally is a pretty small payment, maybe $3 an acre or $5 an acre, that landowners get for agreeing to allow the seismic activity to take place. So it's a pretty small payment. Some landowners will say, no, I'm not agreeing to do that, and then the company will do it anyways, and the landowner may have already granted that right when they signed the lease agreement. So it's a way for a company to just, I guess, be absolutely sure that everything's fine, even though they may actually have that right. Kind of a belt and suspenders approach where you try to just get things two different ways. Okay, so that's what you get. All those are the payment terms. What are you giving up? If you own the surface and the subsurface, you're giving up, when you sign the lease, you're giving up rights in the mineral estate. You're granting them certain rights in the mineral estate, you're granting them rights in the surface estate. I'm going to talk separately about situations when you have a severance of those estates, but right now I just want to highlight the fact that it is possible to sever the surface estate from the mineral estate. And when that happens, meaning the different parties own the surface and the subsurface, it's possible to sever the subsurface into multiple ownership interests as well. But when you have the surface and subsurface severed, the subsurface is dominant over the surface estate. So the subsurface, there's an easement to use the surface estate. Okay, now getting back to the situation where you just have one owner. The mineral or the oil and gas lease is going to specify exactly what products are subject to the grant. So it's certainly going to say oil and gas, and it may have a laundry list of other items. I think a landowner should try to limit it to just what you're getting paid for. Why grant rights to something that has no value now, but maybe it'll have some value in the future? If you're a company, you'd like to get everything, gold, silver, whatever else that's not there, or it doesn't have value, but maybe at some point it will have value. So I would look at that laundry list that's included of the substances and reduce it to just what you're getting paid for. And I think that holds true if you have a local drilling company that only has the capability of drilling sandstone wells, and they want you to sign a lease that's going to grant them the rights to everything, but they're only paying you for the essentially they're only paying you the value that you would get for leasing those shallow rights. Then why grant them the rights to everything if they're not paying you for everything? Dunham's rule is it's based on an old case that essentially means where you have a reservation of a mineral interest. So there was a question or a reference to a transaction where the landowner held on to the mineral estate or held on to the mineral rights. In Pennsylvania, if you just use the words mineral estate, that does not include oil or natural gas unless there was some other indication that that was intended to be included. So if you're looking back through your title history and you see a reservation of a mineral estate, you need to be on notice that likely does not include oil and gas. So sometimes this can have the effect of people who thought they did not own the oil and gas actually do, or vice versa. And it is possible in your lease to just include certain strata. So to have a horizontal severance, so you're just granting rights to certain strata, but not others. That's becoming more common as there are definitely different values associated with different strata. Okay, we had this question earlier, so I think question in the back.
I just had a quick question on what you just said. Has that issue been resolved in Pennsylvania, whether or not the reservation of mineral rights automatically include or does not include oil and gas? Because I remember a U.S. Steel case where they,
yes,
some time ago, where they said that reservation did include it. Is that resolved?
Well, the case you talked about is the Hogue U.S. Steel case, which dealt with coal bed methane. And there was recently a case last fall, the Butlers v. Power estate case, which somewhat revisited some of those issues, but didn't ultimately give us an answer. It just raised questions. And so let me just walk through those two cases. The decision in the U.S. Steel Hogue cases from the, I think, early 80s, 81, 82, somewhere in that time frame. And the Supreme Court ruled that the ownership of coal bed methane, which is gas that's contained within a coal seam, that ownership of coal bed methane is with the owner of the coal seam. So if you own the coal seam, you own the gas that is within the coal seam. Okay? Now, if gas escapes from the coal seam, then you don't own it anymore. But while it's in the coal seam, it's owned by the owner of the coal. And the background of that case, it was I think a lease from the 20s, and it contained the language of all gas. And so the Supreme Court looked at whether all gas included coal bed methane. And they kind of looked at the fact that in the 20s, people knew about coal bed methane. So that's kind of supported the argument that when you say all gas, you mean all gas, you mean coal bed methane. But also in the 20s, it was a dangerous gas. It had it had a negative value because nobody wanted it. So if you have this gas with negative value, why in the world would you include that in the phrase all gas? So ultimately, the court ruled that the ownership belongs, the intention of the parties was that whoever owns the coal bed methane. Okay, now the Butler v. Powers Estate case, which was a Superior Court decision last fall, the facts of that case, there was an 1883 deed reservation. So there was a real estate transfer, but the grantor reserved rights in the mineral estate. And I think under Dunham's rule, I think the general expectation or understanding in Pennsylvania was that since there was no mention of natural gas, that was not subject to the reservation, that was conveyed. But the Supreme Court looked at the Hogue, the U.S. Steel case, and basically said, well, we need to find out whether Marcellus Shale is a mineral. So when you have a mineral reservation, was Marcellus Shale a mineral that was reserved? And should Marcellus Shale be treated like coal bed methane, or like coal, where if you own the Marcellus Shale, you own, let's say Marcellus Shale is a mineral, then if you own Marcellus Shale, do you own the gas that's within the Marcellus Shale? And so they raised these questions and then remanded it to the county court to resolve those issues. And then that has been appealed to the Supreme Court. So right now the issue is at the Supreme Court. So we don't have a definitive answer on the questions that were raised by the Butler case. Now that could, depending on how it's resolved, that could really change the application of Dunham's rule in Pennsylvania.
Is that state or federal Supreme?
That was state. I'm sorry, everything that I said was state. So it was the Pennsylvania Supreme Court that issued the case dealing with coal bed methane. And that law changes from state to state. It's not the Pennsylvania rule that the owner of the coal owns the coal bed methane is not followed everywhere.
In fact, I think that's kind of unique to Pennsylvania.
Yes. Yeah, Pennsylvania is somewhat of an outlier in that. So in this current case, the courts are going to have to either do away with Dunham's rule, or they're going to have to somehow reconcile the coal bed methane with the current situation. And I think one way of reconciling it is to say that coal has value. I mean, you extract coal. Shale has no value. You're not going to mine shale that's 1.5 miles below the surface. At least, not at this point. It's not economical. So that may be one way. Okay. The surface estate, again, we're talking about the situation where the rights are unified. Generally, an energy company is going to want to seek broad use of the surface estate. A landowner is going to want to limit that based on how the landowner uses the property. And the landowner can put whatever restrictions are negotiated in that lease agreement. So, one that I think is very beneficial for a landowner, and companies are often willing to do that, is to require that the landowner has the final say as to where well sites and access roads will be located. So you can't completely deny that a well will be on your property, but if it's in the middle of your best agricultural field, you can shift that so it's going to be by the edge of a woodlot or an access road. You can make the facilities fit into how you're going to use the property. You can specify how the land is going to be reclaimed, so you can go beyond what's required in state law. You can specifically define the structures are located. Compressor stations are one that I think 5 years ago people didn't think about compressor stations. But I think you have to be a little knowledgeable about what the industry actually does. How would they plan to use your land and protect yourself? But you also have to look in the future a little bit, which is difficult or maybe impossible. But how could they use your land in the future? But you can define those specific activities. Maybe you just say they're only allowed to construct a well and no auxiliary facilities. You put something that is going to impose a limitation.
Would that be in the addendum?
Yes. I mean, when I say in the lease, I'm talking about the documents all collectively, because the addendum is going to have, probably the first thing it's going to say is if there's a conflict between the terms in the lease and the addendum, the terms of the addendum control. And so it's going to incorporate them together so they are all considered legally one document. So I'm glad you asked the question, because just to highlight, they are one document. They're incorporated together. It's just practically the addendum is what you are negotiating based on the terms that are included in the lease agreement.
Lately, there's been some concern about air quality near drilling sites. Is this the sort of thing where you might specify some restraint on emissions or some sort of reporting requirement?
You could include requirements on emissions. Now, I mean, you have to keep in mind this is a part of a negotiated process, and a company might say, "Well, no, we're not going to agree to that." But I think a good approach to take is maybe you don't ask for absolutely everything, but you ask for what you want to have in that agreement, and they're probably going to come back to you with, "Well, we'll agree to everything except this," or "We'll agree to this, but we won't agree to that." And there's not, my experience is you don't have a lot of back and forth. I mean, for the most part, the company presents a lease, the landowner would prepare an addendum, the company will say, "We'll accept these, we won't accept these," and then the landowner has to make a choice. What are any of these provisions deal breakers? Am I willing to sign that, sign it or not? I mean, you could go back again and go back and forth, but my experience is that it's pretty much probably a 3 or 4 step process.
And then just to double check, the most recent addendum is the one that has the most precedence, correct?
Well, you're going to sign all of these documents at the same time.
Okay.
So you're not going to sign a lease and then a year later sign the addendum. You're going to sign all of the documents at the same time, and then you have to look and make sure there's language that specifies what the precedent or what the priority is. So if you have, let's say you have an example where the company presents you with a lease and they have an addendum that they're presenting to you. I mean, if I were looking at that, I would prepare another document, call it a second addendum, call it whatever you want to, but that second addendum then is going to have language saying if there's any conflict in the terms of this second addendum with terms in the lease or the addendum, the terms of the second addendum control. And you'd have a similar statement in the addendum so that you have a clear priority. The second addendum is the top. Then you look at what's in the addendum, then you look at what's in the lease.
When a property owner signs a lease, he's not only putting his or her property at risk, but he's also maybe putting the community at risk. What kind of oversight, other than the 1/8 rule, is available by the state? And is there oversight in the offing to help the homeowner not do stupid things?
Well, there are some protections in state law that impose some setback requirements. impose some requirements on reclaiming the property. So I mean, there are some state laws that govern the activity, and
Is there a state agency?
the Department of Environmental Protection with its Oil and Gas Bureau. And yesterday I gave a presentation on the statutes and regulations. So is that they can?
It would be
Okay.
in that, because that has your full
Okay.
presentation from.
So they're incorporated in that.
Mhm.
Okay. A landowner can also negotiate a no surface rights lease. So with horizontal drilling, the company can come under your land without coming onto your land. So you can, as a surface owner or as a landowner, the best lease to minimize surface impact is a no surface rights lease. So they're not going to be able to come onto your land. And companies are willing to give no surface rights lease, generally for the same price that they're giving other landowners. Okay, in your lease, I think you want to protect the property damages. You know, if your land, the agricultural productivity, timber, your buildings, your water, if there are any damages, make sure the company is agreeing to reimburse you and that you're agreeing how you're going to value those damages. Because that valuation decision can make a huge, huge impact on what the dollars that you receive, the compensation you receive. If you are sued by a third party, let's say someone's riding a snowmobile on an access road and they get injured and then they sue you as the landowner, you want to include an indemnification clause so that the company will reimburse you. And that certainly doesn't address all issues, like if you have a situation where the lessee were to go bankrupt, but you still, it's better protection for yourself to have that indemnification. Okay, let's just kind of mention this. Okay, storage. Your lease may provide for storage or pipeline access. I think you want to pull those out of your standard lease agreement and negotiate those separately. Just with pipelines, I've seen a lot of pipeline right-of-ways that did not specifically indicate where the right-of-way was. And so basically the landowner was granting the right to the company to put a pipeline wherever they wanted to put a pipeline. And I think a pipeline can cause a greater impact to your long-term use of the land than what a gas well can, because it's going to take more land, and you're going to be limited in what you can do on that pipeline. You know, you're not going to be able to put a house, you're not going to be able to plant trees, a lot of things you can't do on the pipeline. So I think you need to make sure that you know exactly what land is subject to the right-of-way. You have a survey done so that they're showing you exactly where that right-of-way is going to be placed. Okay, you know, I think this is obvious, but natural gas extraction involves some disturbance to the surface estate, but it doesn't involve a disturbance to every property, you know, because of the horizontal drilling. Just to compare Marcellus with traditional wells, the well pads on Marcellus are going to have a much greater surface disturbance than a well pad for a traditional well. And that's because of the high amount of water that is used, and because you have multiple well sides, or the potential for multiple wells on a single well pad. Now, on the other side, you have fewer well pad sites with Marcellus wells than you do for traditional wells, because you can put the multiple wells, because of the laterals, you're able to cover a larger area with one well pad. And I'm not here to debate whether, you know, one offsets the other, but the fact is, if you're a landowner and you're thinking of your individual parcel, you need to recognize that if a well is on your land, it's going to be a much greater surface disturbance than a traditional well, but it's also possible that your land will not be disturbed at all. Okay, we talked about the severability and the right to the fact that the subsurface is superior to the surface estate. The owner of the surface estate is entitled to certain notifications. So you have to be notified when drilling is going to occur, or when the permit is applied for, and then also right before drilling happens. But the owner of the subsurface estate is entitled to make reasonable use of the surface estate. So, you know, they have to send you, as a surface owner, the notice of the permit application. You have 15 days to object 15 days, not a long time, but you have 15 days, and the bases for objecting are pretty limited. Only on the location of the well, that it's violating one of the statutory setbacks, or that they have inaccurate information in that permit. And then you also are notified 24 hours before drilling. Not a lot of time, but you have 24 hours notice.
Is that only within 1,000 feet, or is?
This is the surface owner where the well is located. So if you have a water supply within 1,000 feet, you're entitled to certain notification of the permit. But as far as both of these notification requirements, it is just the surface owner where the well is located.
Is this in Pennsylvania alone, or is this?
Pennsylvania. It's Pennsylvania, but this pretty much falls in line with the general law, that the subsurface is dominant. The extent of the reasonable use might be a little bit different. There's an accommodation doctrine. Exactly. The notification, that's purely statutory in Pennsylvania. But the gist, and I'm not going to have time to really go through the facts of this case in detail, but it was a Pennsylvania Supreme Court case from a couple years ago, and the outcome of this case is emphasizing or is reiterating the fact in Pennsylvania that subsurface owner has the right to make reasonable use of the surface estate. I mean, when those estates are severed, the holder of the gas rights has an implied easement to use the surface estate. Now, okay, what is reasonable use? That's very much a factual determination. And what happens if you're the surface owner and you think that a company is going beyond reasonable use? Well, your options, I guess, before you get to that point, if you're in a situation where you're the surface owner and you don't own the natural gas rights, you can approach the company and try to negotiate a surface use agreement. Now, they are under no obligation to do that, but the reason that they would have, the incentive that they have to do that is they know, they buy certainty. They know that you're not going to file a suit against them. And this surface use agreement can specify where a well is going to be located, where access roads are going to be located, and it might provide some compensation. But again, the company's under no obligation to negotiate a surface use agreement. So if you think that a company is going beyond or intends to go beyond what would be reasonable use, the burden is on you as the surface owner to file suit to get a court action to limit or stop their actions. So I think that's really the gist. As a surface owner, you have some rights, but you're not going to be able to stop the development unless you can prove that this is going beyond reasonable use. I think with that, I'm going to compensation. We have a question. We'll go with a question.
When the land is sold and the gas rights are severed from the surface rights, is there any wording in a deed? Can wording be put in a deed that holds any water over?
Yeah, you could put language in the deed when the estates are severed. The question was, is there any language that's in a deed that could provide rights to the surface owner? Yeah, it could. That's not common. I mean, for the most part, there's a severance. But, I mean, you could put some language in there that would provide for, you could say that compensation would be required or any other restriction. And it would be, that would be part of the grant. I think it would have to be pretty carefully drafted, but in theory, you could do that. But again, I don't think I've ever heard of that actually happening, but I don't see why it couldn't. Compensation for damage to the surface estate. There are no statutes in Pennsylvania that provide for compensation, and I think even in the case law, there's really limited authority that provides that landowners are compensated when their land is damaged. Obviously leases address that, but when you're dealing with severed estates, oftentimes companies will provide compensation. But if they don't provide compensation voluntarily, I think there's really limited authority for the landowner to get compensation.